So, good afternoon, ladies and gentlemen. My name is Miss Natasha Jean. I am from the beautiful island of Seychelles. I am currently pursuing my online degree with Segi University for a Bachelor in Business Management. And today I will be presenting a presentation mainly on cyber law, but specifically focusing on online defamation and the legal challenges that arise in Malaysia's digital context. And also, throughout the presentation, we will be analyzing a real case, Tong Sik Khan and Anor versus Lok Akin and Anor. What is online defamation? Let's start by understanding exactly what online defamation is. For me, I will call it a civil wrong, where someone publishes false statements online and that false statement damages another person's reputation. Some cases can even cross into criminal territory if the communication is malicious, threatening, or knowingly false. As the internet and social media platforms grow, so do the legal risks that come with public posts. Online defamation involves making false and harmful statements about a person or entity through digital platforms such as Facebook, Instagram, blogs, or website. So now we'll talk about the case. In this case, the plaintiffs were Tong Sik Khan and another member of the Tong family. They discovered a blog making defamatory statements about them. The blog was anonymous, but eventually traced to the defendant Lok Akin through a legal process involving Google and Telekom Malaysia. The key issue here was authorship and whether that person could be held responsible. Okay, so the fact of the case was the defamatory blog posts were published anonymously through Blogspot. The plaintiffs obtained a U.S. court order forcing Google to reveal the IP addresses of the blog owner. Those addresses led back to Telekom Malaysia and ultimately to the defendant Lok Akin. Despite denying involvement, he could not disprove the connection. Now we will look at certain key legal questions that emerge throughout the proceeding. So these questions were mainly: were the posts defamatory? Can the defendant be presumed the author through IP evidence? Does Section 114A of the Evidence Act apply retrospectively? And last but not least, can someone escape liability just by denying authorship? These issues challenge how courts apply traditional legal principles to online behavior. In my next slide, I would like to talk a little bit briefly about Section 114A. Section 114A shifts the burden of proof in internet-related defamation cases. If a statement is linked to your IP address or device, you're presumed to be the publisher unless you prove otherwise. This law helps address online anonymity, but is controversial because it reverses the usual burden of proof. The Defamation Act 1957 and common law define defamation clearly, and this includes online content. Section 114A helps court manage cases where authors are anonymous. Section 233 of the CMA 1998 criminalizes offensive or false content online. John Doe orders, like the one that was used here, are also a tool for identifying anonymous authors across jurisdictions. Now we will move forward to the case law analysis. So, in this case, the plaintiffs relied on cases where courts upheld the use of digital evidence and applied Section 114A, including STEM Life, Husa Musa, and Fo Hiap Siong. The defendant denied authorship and argued that Section 114A shouldn't apply retroactively. However, the court found these arguments insufficient and sided with the plaintiffs. So the judgment of the court. The High Court ruled in favor of the plaintiff. The court held that the content was in fact defamatory, the connection to the defendant was established, and Section 114A was applied. The defendant failed to rebut the presumption and was ordered to pay 600,000 Malaysian ringgit in damages. That's a strong message from the court. In summary, this case shows that courts are capable of handling online defamation effectively. Digital footprints can be traced, and anonymity won't always protect the author. My recommendations are: individuals must always be cautious with what they post online. The legal system should continue and keep on evolving, and platforms such as Facebook, Instagram, Twitter must cooperate with legal processes to prevent abuse. And as we always say, justice has been served and the plaintiff has won his case. And this is the end of my presentation. And I thank you, ladies and gentlemen, for listening. And I hope that my presentation has clearly elaborated a little bit more about cyber law and online defamation, which is happening in a lot of countries. And I will relate to here in my country, which is a small island of 100,000 population, whereby people just post anonymously on platforms like Facebook and Instagram, and some things that are being said, and most of the things that are being said is just trying to tarnish someone's reputations, and also politics wise. And I think that Section 114A in the Malaysia law, in the Malaysia law, in the Evidence Act, is something that Seychelles should try to incorporate it in our law here, so that people can be protected under the law and that it can prevent these types of online defamation, whereby someone's reputation can be tarnished just overnight. And some people care a lot about their reputation and what people think about them, and we have seen in other countries whereby a simple post can cause someone to commit suicide, because it can be just a sentence, and that sentence can tarnish the whole life of that individual. So this presentation while doing it has helped me to also understand really a little bit more about online defamation. And I am aware now that some countries have a law that can protect individuals from it. And I thank you once again for listening, and I invite the audience for any questions. And thank you once again, ladies and gentlemen.